still awaited? Yes. Then yes, DCI is awaited when it is not received. Where from it has to come? Kamrup. Kamrup wrong. Scan copy of the DCI is not received. I should reminder registry will do the needful. Let's the matter accordingly. When it can be done. Twenty. 20. Oh, it's a holiday. Huh? 22nd. 22nd. Just like, yeah, what had happened actually, I noted down everything and I was supposed to dictate the matter yesterday when I was trying to dictate the matter. Then it has come to the notice that the order which against whom Mr. Chauhan you have filed the interlocutory application for stay of that order was passed by Justice Robin Fukon. So matter should be placed before the appropriate bench, I think. Otherwise, it will be create another. I mean, it should not be my opinion. Should not be differ with the opinion because I have already heard. I have noted down everything. I was supposed to dictate yesterday. Then only it has come to my notice. So I'll just pass the order list before the appropriate bench. As question is that only that the order which was been not challenged, but which against whom against the order you have come, this order has been passed by Justice Pukon. So better to list before the appropriate bench. Okay. Heard Mr. S. Chauhan, Learning Prosecution, also heard Mr. R.C. Sarkar, the learned senior advocate, assisted by J.P. Burba, uh, uh, as the order which was the present interlocutory application has been filed uh, for stay of the order for the stay of the order for interim stay of the order dated 06/09/2024 passed in civil revision bracket of IO number 325 of 2024 and that the order has been passed by লিখে দিন দাঁড়ান করা হয় so that is the order of so and so and accordingly I find it that it is court is better to be listed before the appropriate. Okay, it will be listed before appropriate batch. I have already narrated. It will be listed accordingly by the registry. You have already filed. Achha. Additional affidavit is with us before the already. Okay. What is the position we call for? Huh? Achha. Oh, achha. So to that additional affidavit, we have already filed a rejection order. So now we can call for the scan copy. Part Mr. GOT, learned counsel for the petition. Part Mr. K. Learned additional PP, bring it is submitted by Mr. Udit that the additional affidavit has already been filed, bringing the early rejection order into the record. That the scan copy of the DCR call for registry will do the needful, list the matter accordingly. It will be on 27.
Hearing attempt to
Yes, here we have received this scan copy. I think you as an amicus. Yes. Just I'm not following you. What you say? On for many. On video. Yeah, on switch on the mic. Yes.
Lordship, I do not want to go on the merit of the case. My only humble submission is that Section 50 of CRPC, now Section 47 of BNSS, the grounds was not fulfilled when arrest was made. So therefore, Lordship, the only on this ground, the bail may consider. Is my humble submission. Also, it is very evident from the landmark judgment passed by the ethics court, that is Bihan Kumar versus State of Haryana, where non-compilation of non-compile of grounds, where grounds were not given in the arrest memo or in the notice under Section 50 and Section 50A of CRPC, the arrest and the remand itself is illegal. So this is my humble submission, Lordship.
So you do not want to make any submission on the merit of the case.
Yes, Lordship.
Yes.
My lord, I have gone through that, my lord, regarding because it is on the ground of arrest, my lord. Here, my lord, the date of arrest is 18/3/2024, my lord. And my lord, that is that order of my lord. I have, my lord, tagged my
The divorce made. Date of let's say date of arrest is of
18/3/2024. My lord, 18/3/2024.
24.
I was lodged on Saturday, 2024, on 18/3/2024. My lord, already, my lord, search frame, my lord, it is in the, my lord, trial is going on. As per the record, my lord, that is available on record, my lord, 13/9/2024, my lord, PW7 was examined. It is not on merit because, my lord, on the arrest. The production order, my lord, I have tag mark, my lord, there. In the, my record. The record.
So from the production order of production, what do you want to submit?
My lord, here only, my lord, that is a part of that is a legally counsel, my lord. That word is only there. That part is there, and my lord, my lord statement is, my lord, that is he was hard, my lord. His one statement is there. He will appoint, my lord, that his family, my lord.
It It's a POXO case.
My lord, POXO case 4 years, my lord. He was 4 years, my lord.
Victim was 4 years old.
That time. That is incident occurred on, my lord, 16/3/2024, my lord. And my lord,
The order. I have. I have heard the submission made by the learned counsel, both sides, and also perused the case diary, and it is seen that FSL report is still awaited, which was sent for examination the initial stage of investigation. But till date, the IO could not collect the FSL report. It is seen that the accused petitioner is in custody since 63 days, and hence, without going into the other of the case, I find that IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody for a considerable period. In view of the above, I find the may not be for the purpose of investigation. However, the petitioner will extend his cooperation, and when it is needed, like so 63 days your lordship has already allowed. I am all there for 82 days. And moreover,
Yes,
they have not
sure.
saved the case diary.
Most probably, Mr. Bharat submitted that one. It is a co-accused, huh? Case of the co-accused was considered on the length of detention. So do you have anything, any other submission?
because, my lord, my lord, CD is not available with us. My
This case was also earlier rejected or
Earlier rejected.
earlier
Earlier
rejected? Have you annexed the rejection order?
That's not okay.
In which page it is?
That is not mentioned, but few of the other accused, they have gone to Supreme Court as per the, as against the earlier rejection order. In that also Supreme Court has granted them interim date.
Interim.
Interim.
Two orders are here.
You are one of the engineers, I think.
One of the, page number 2, second paragraph, it states that earlier it was rejected.
Orders.
Yes, obviously, the co-accused, one of the co-accused was granted the 63.
But Verity may not come, my lord, because my earlier, my lord, it is rejected on 28/2025, my lordship. And after perusal of the, my lord,
Ah.
my lord, can I make a prayer, my lord? Can it be on, my lord, this week itself, my lord, on 17th? Or my lord, on 17th?
No further time may be given me.
82.
82 days I am there.
See, so far I can remember the case record. There was most probably it was a case of a suicide case.
My lord,
They all were, all the engineers, the contractors, the architects
my
were
lord, that was the
allegedly
FIR, my
be
lord.
involved in
Yes,
this case.
They all released.
Obviously, there are some part of investigation was there,
Yes,
and we can only consider the 82 days of custody, that much only.
on the land.
Only on the length of
On-
detention. We're not going to the details of the other merit of the case. And
Because-
one got the most probably interim in one anticipatory bail for one contractor, I think. And the other one we have granted bail by this court, only considering the length. But obviously there are the involvement of the other one and this one
Yes,
may
ma'am.
be
Because he is
different
man
because
of
he
the
is the main accused, I think, who was involved in was involving it. Anyway, but 82 days is quite a sufficient day.
My-
Do you have any information that within this period any charge sheet will be filed or not? That kind of information, do you have any?
That information, my lord, right now I don't have. I can take a telephone.
Because some FSL
Instruction,
report
my-
was still awaited when I passed the order.
My lord.
Those were sent because the all recordings were there, some the
Right.
audio clips were there, and those were sent for FSL.
FSL.
report, and that report was awaited.
Right.
When I passed this order, one of the quick,
Right.
I can still remember. But I don't know within this period if it has already been received or not, that I don't know.
Right.
Let it consider only the length of detention.
Right.
But Mr. A.K. Bhattacharya, the learned senior advocate, assisted by Mr. D.K. Bhattacharya, the learned counsel for the petition, also heard Mr. K. Bush, the learned additional PP, appearing to be upstairs. C did not receive. However, it is submitted by Mr. Bush that it is wrongly there was a
Miscommunication, my lord.
miscommunication of the number of the case diary,
Right.
and for which the case diary could not be received. In that context, Mr. Bhattacharya and senior advocate submitted that the accused is in custody since last 82 days, and hence considering his length of detention, prayer may be considered. He further submitted that the IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody, and hence further custody interrogation may not be required for the purpose of investigation. Mr. Bhattacharya also submitted that one of the co-accused has also granted bail, considering the length of detention. Length of detention. Next one, Mr. Bush, the learned defendant PP, raised objection and submitted that considering the nature of the offense, the prayer may not be considered, and investigation is still under process. However, he submitted that the accused petitioner is in custody for reasonable period, for quite a considerable period. Next, but hearing this submission made by attorney counsel for both sides, without going into detail of the merit of the case, only considering the length of detention, also considering the fact that the IO got sufficient opportunity for interrogation, the accused petitioner, keeping him in custody, I find further custody interrogation may not be necessary for the purpose of investigation. Okay, we are granted with bail.
Yeah, please.
Yes.
Here, earlier rejection order, your lordship will get at page 103.
Here we have received the scan copy. I think.
Yes.
There are just two things and on lordship. First thing is that lordship on earlier occasion, your lordship will find that at paragraph 13, that is page 108, the learned PP submitted that there was warrant of arrest, and on that ground he was arrested, and therefore that written grounds of arrest, communicating the written grounds is not required. So that was the submission, and accordingly your lordship also held that there was warrant of arrest, so it was. So I have filed one application before the learned trial court so that a copy of warrant of arrest may be granted. Then they verified and there was no warrant of arrest. Actually, it was a transit remand order. That transit warrant, that transit order is, your lordship, in my humble submission, to my understanding, it is like a custody order. That for temporary custody order. That for this from Bangalore to Assam, you have to go there. So you cannot produce the accused person to the before the magistrate having jurisdiction within time. So I am granting you some time for custody. That is the order. But there is no warrant of arrest in the present case. And my second submission is that, lordship, that he is already in custody for 2 years, 7 months, 12 days.
2 years?
7 months, 12 days. And last witness was examined in the month of February, lordship. That is 1st February to 2025. And after that, no witness turned up. That PW10 I have enclosed here also. Page 81, 1st February 2025. Thereafter, no witness turned up. And now the case. Now the case is fixed on 3rd of December. And in the rejection order, your lordship directed to conclude the trial within 6 months. And last part, your lordship will find that observation also. And probably that will not be concluded within 6 months, lordship. That page 113, that direction is there. Paragraph 18, last part. And after rejection of his bail prayer, other two accused persons, lordship granted bail. That is page 114. On 19/8/2025, considering that there are no grounds of arrest were communicated to them, as well as the delay in trial, concluding the trial. That part. And regarding that grounds of arrest, lordship, that lordship may kindly say one aspect. I'm just clarifying that aspect, lordship. Notice and lordship arrest memo, lordship may kindly see page 97. That is down below, your lordship will get the IO signature 25/2/23. On that day, he was arrested and forwarded and produced before the court in Assam on 28. So those the documents were handed over to him on the same day. So that is not a case that he was arrested on the with warrant of arrest. So no, nothing has to be given to him. That is not the case. For that purpose, I am showing the dates. And second memo of arrest, your lordship will get page 100, lordship. Here also date of arrest and signature 25/2/2023. So these documents were given to him, taken his signatures, all this 25, and forwarded, lordship. That forwarding report I have enclosed, page 18. That is on 28. Page 18, 28. So if they have handed over those arrest memos and other documents, they could have supplied him those grounds of arrest. And my learned friend can verify that whether any warrant of arrest is issued by any competent court or not, that he can verify. And transit remand cannot be, in my humble submission, treated as warrant of arrest, because that is only a temporary custody order.
Yes, my lord, here, my lord, on my lord, earlier occasion, my lord, when the order was rejected, my lord, I can be evidence the please, my lord.
One 103
One thing. Can we reduce my lord 109, my lord? May come to 108. 108.
Yes.
My lord, this, my lord, petition was rejected on my lord 76/2025. Till then, my lord, that is the custody when the this came has already come, my lord, after Bidhan Kumar. Now, my lord, we have another, my lord, more explanation by the Honorable Supreme Court, Darshan's case, my lord, State of Karnataka versus Darshan, my lord. Here, my lord, was pleased to, my lord, consider the ground, my lord, that's my learned friend, when he submitted that, my lord, as because the arrest was made on, my lord, 25, my lord, 2023, my lord. On the strength of the, my lord, warrant. That is the warrant is obviously, that is a, my lord, transit warrant. That is a transit warrant, my lord. Because he was, my lord, that time arrested, and accordingly, he was, my lord, my lord, produced here, my lord, before the court of the CDM on 25 to 2023. My lord, 28 to 2023. Now, my lord, that is the relevant part of the my lord Kasi Reddy and Upender Reddy's case, my lord. Here, my lord was pleased to my lord discuss everything, my lord. My lord, may kindly come to page 109, my lord. 109. 109, my lord, the bottom of the page, my lord. My lord, that is the 36 of the paragraph of the my lord Kasi Reddy's case, my lord. If a person is arrested on a warrant, the grounds of reasons for the arrest is the warrant itself. Now, my lord, here, my lord, the Honorable Supreme Court, my lord, when my lord this passed this judgment, my lord, they are not, my lord, categorically defined or my lord, it is categorized, my lord, sorts of warrant, my lord. The word is used as a my lord warrant, my lord. So, my lord, on that point, my lord, I am not, my lord, submitting, my lord, because already my lord was pleased to, my lord, reject this order. My lord, thereafter, my lord, after my lord Darshan's case, my lord, it was very much, my lord, clear the, my lord, that is the object of providing these notices, my lord. But in earlier matter also, my lord, have submitted. So, my lord, this object is there. So, there should not be any demonstrable prejudice, my lord. A ratio should be laid down, my lord, and the accused must get the opportunity, my lord, defend his case, my lord. Now, my lord, again, I am verifying the production order which is available. That is on my lord 28 to 2023, my lord. Here, my lord, because my lord, he was arrested on the strength of a warrant. Obviously, that warrant is a my lord transit warrant, my lord. And my lord, on 28 to 2023, he was produced before my lord, that is the JMFC, my lord, herein, my lord, where, my lord, it is, my lord, that stated, my lord, that is the accused heard the submission of the accused person regarding engagement of advocate for defending him in this case, my lord. The accused person verbally submitted that his family member will engage learned counsel to defend him in this case. My lord, that is the arrest on 25/2, and my lord, that is produced on 28 to 2023. My lord, from this, my lord, that is the submission of the accused, my lord. It is clear that, my lord, that is the object of both the notices, my lord, is fulfilled, my lord. And he is, my lord, he is ready to, my lord, get the opportunity of defense from the engaged lawyer, which will be engaged or which was engaged. My lord, that information was there from the family, my lord. So this is my submission, my lord. The order, my lord, it is the production order. I have, my lord, tag mark. Admittedly, my lord, in the 50 notice, my lord, those grounds of arrest, my lord, not in the written format. My lord, I am relying, my lord, Darshan case as because, my lord, that is after, my lord, Kasi Reddy's Upender Reddy's case. Kasi Reddy's Upender Reddy's case is also, my lord, earlier, my lord, that is relied on. That is, my lord, that submission is already, my lord, in the record. And you produce that order. Regarding that part, my lord, this is my submission.
Regarding that, Lordship, whether prospective, retrospective, that your Lordship has elaborately dealt in the order, rejection order itself, so that I am not repeating those things, Lordship. On only one thing, Lordship, that my learned friend says that transit remand can be treated as warrant. That cannot be, Lordship, because that transit remand order, that clause is, it's a power from section 187. Section 187 says that within 24 hours, a person who is arrested has to be produced before magistrate. So I was arrested on 25. They could not produce me within 24 hours. So they have produced me near the nearest magistrate, Lordship, of Bangalore. So then that court pass an order that you can take interim custody of that accused person. So that is after arrest, not prior to arrest. That remand order. And that remand order nowhere nowhere shows, Lordship, that's why I was arrested, on what grounds I was arrested. And if that is so, Lordship, that search warrant, if a search warrant is issued, that police cannot say that I was having search warrant, so I have arrested this person. That cannot be. There are specific provisions are there. They have to follow that protocol. That is my humble sir.
Your part. Yes, sir. Okay, I'll pass you. It is.
May please, your lordship. I am appearing in item number 6, madam. It's
Well,
the,
what we need, we have need the.
My lord, updated CD was called for, my lord, on an earlier occasion, my lord, because my lord, earlier it was rejected on 24/7/2025, my lord.
Acha.
The day after, my lord, as because that CD was not updated, my lord, that was called for, and we have received the same updated CD.
Now you have received.
Yes,
the rejection order is at page 27. Madam, page 28, my lord. If you allow, page 27, last line, my lord. He further submits
Hmm.
that as per the medical report, the victim sustained grievous injuries on his head and other parts of the body. There is also a serious allegation that all the petitioner attempted to commit the murder of the victim. Accordingly, he raises a strong objection to grant the pre-arrest bail. This was ultimately, my lord, your lordship had rejected the same. Now, if your lordship turns to, my lord, the FIR, my lord, at page 15, the FIR is at page 15. May I read, my lord? With due respect and humble submission, I beg to state that on so and so at around 10 a.m., my cousin brother Ijahar Ali took his motorcycle to the garage of Sabir Ali, situated along National Highway at so and so for repair. At that time, a group of 12 to 14 persons came out from the hardware shop situated next to the garage of Sabir Ali with an intention to kill his brother, assaulted on his arms with rod, dagger, and tube wells handle, and the accused broke his two arms and inflicted severe injury by stabbing on his head with a dagger and also injured him in various parts of his body. In due time, one person named Rejakul informed us from there over phone and immediately took the victim to the Mongolday Civil Hospital. Though the doctor referred the victim to GMCH due to severe injury, but he was undergoing treatment at GNRC for better treatment. Now the next page, my lord. My lord, below, my lord, the case is received and registered by Bhula PS case number so and so, my lord. Now, lordship will see, my lord, 109 is there, my lord. 109 is, my lord, grievous hurt by dangerous weapon. The punishment is life, my lord. My lord, secondly, 118(2), my lord, voluntarily causes grievous hurt, that is bailable, my lord. And now, my lord, the first section, my lord, 189 within bracket 2, my lord, it is, my lord, unlawful assembly. Yes, we are there, my lord, but we did not participate, my lord. So therefore, my lord, that unlawful 189(2) is unlawful assembly, my lord, punishment is 6 months, my lord. And now, my lord, the most interesting, my lord, the police has not registered the case, my lord, the common intention 34, my lord. So there was no common intention. Now it will be, my lord, section 3 within bracket 5 of the PNS. So 34 was not.
189 is what we wanted.
Section 34 of the IPC.
No,
Now-
189.
189 is unlawful assembly.
That is 147, 148.
Yes, well, that is, well,
is
6
there.
months. Bailable, man.
Whatever that is there.
Well, that much, my lord. And now, my lord, in this case, my lord, one person has been arrested, my lord. Well, I will show that, my lord. Page 41, my lord. Page 41, my lord, Annexure 5, my lord, that one person, my lord, Bilal Ali has been arrested. Now, if a lordship sees, my lord, the grounds of arrest, my lord, number 3, my lord. Lordship have found, my lord, from the statement of the witness, namely Sabir Alam and Jiaurul Haq under section 183 BNSS, it has been revealed that they saw the above noted accused person attack the victim with dao, iron rod, and other heavy things, my lord. Now, if as your lordship had already, my lord, called for the up-to-date case diary, my lord, that may be perused, my lord. I don't know what is in the case diary, my lord. My friend will say.
Yes, my lord, CD receipt, my lord. Here, my lord, 12 numbers of my lord petitioners are there in my lord item number 6, my lord. And my lord, item number 7, my lord, 1, my lord, petitioner. And my lord, here, my lord, all my lord, that is the petitioners, all are FIR, all are FIR accused. And my lord, here, my lord, that is earlier, my lord, rejected on 24/7/2025, my lord. Is the earlier when my lord it was rejected, my lord, 24/7/2025, my lord. In item number 6, my lord, all the my lord petitioners, my lord, that time my lord came before this honorable court, my lord. Now, my lord, after 24/7/2025, my lord, we have received the updated serial. And some relevant part, my lord, I have my lord tag mark, my lord. Like some green flags are there, my lord. After that, my lord, both my lord, horizontal and vertical, my lord.
Yes.
Yes. So, my lord, I kindly produce the last part, my lord, last two notes, my lord. Two notes.
Progress report.
Yes, my lord, they sent for that, and before that, my lord, another one is there, my lord, on the two notes, my lord.
In the earlier note,
My
uh, there are names of some of the
My lord, we found that, my lord, they are ready to, my lord, give us the files, submission of the report. Those, my lord, those names are, my lord, that is, they are also, my lord, available here, my lord. One of the, my lord, petitioner is Saidu, who is the, my lord, petitioner number 2, the accused number 2 of the FIR, my lord. One is, my lord, that is the Wahidul, my lord, Rahman, who is in the petitioner number 2 of the petition, and also, my lord, accused number 3. And another one is, my lord, Mizanur, my lord. Mizanur, my lord, he is the accused number 14, and my lord, petitioner number 8.
My lord, I didn't make one submission, my lord, that petition number 8, my lord, he got arrested. Petition number
whose
8,
name is name
Mizanur Rahman, he got arrested.
already I recall.
Do you have?
So your petitioners named your petitioners names are
My petitioner names are, my lord, Safiur Rahman,
Safiur, my lord.
Safiu.
One is Safiur Rahman. One is, my lord, Saidur Rahman.
Hmm.
Saidur's name is there, my lord.
Hmm.
One is Waidur Rahman, my lord.
Yes.
One is, my lord, Isadul Haq, alias, my lord, Isadul Hussein, my lord. One is Habibur Rahman.
Hmm.
One is, my lord, Bulbul Hussein. One is, my lord, Siddiq Ali. One is Mizanur Rahman. Already, my learned senior has submitted that, my lord, he was arrested, my lord, Mizanur Rahman. Ajizur Rahman, Saivar Ali, Sattar Ali, Rahmat Ali.
These are six.
These are my total 12 numbers.
No,
Well-
no, he is appealing for how many?
12 numbers.
12 is there, now
One
11.
is in fact was so 11 numbers of petition.
And
eight-
other case you
Other
have
is my Sotku Sek.
Kusek in item number
Item number 7, my
so to say.
Sotku Sek.
Kusek.
Sotku
He is
Sek.
the father of the accused number 1 to 5 of the FIR.
Everything is material.
The father of that. He cannot.
Okay, I have marked this.
Right.
We'll see.
And my lord, otherwise, my lord, injury is serious already, my lord, when rejected. My lord. Photographs also, my lord, they annex.
Yes.
No,
No, yes, we have
photograph
already-
is not available.
Photographs are-
Yeah, so-
Any other submission from this?
My lord, my friend is saying, my lord, petition number 1, 2, and 3, there are materials. But I came to now, my lord, his submission, my lord.
Otherwise, my lord, implications are there, my lord, regarding all my, because my lord, in the, my lord, I have flag mark, my lord, there is the 180.
You're representing Bilal also?
Yes.
Sure.
Billal. Huh? No, my lord, Billal is not there. my lord. Bulbul is there.
Farid?
Farid, no, my lord. Farid got arrested. Billal also arrested.
Bilal got it.
Billal and Farid got arrested. And recently Mizanur Rahman.
Yes, and in the submission, Mr. Hussain?
So far the, my learned qualification status. There is maybe there is no information that there is Kusek. He is the father of the accused number 1 to 5 now, 5 years old. And that's why as a whole whole family was incorporated in the FIR, and in that sense, my lord, his name was incorporated, my lord, in the FIR, because he is the father of all the main 5 accused, my lord.
My lord, this is not my submission, that my lord, he was not implicated, my
No,
lord. In earlier, my lord, when rejected, my lord, even my lord against Sotku Sek also, my lord, 180 statements are there. Even victim has, my lord, 183 statements, those are also available. My lord, what I am, my lord, highlighting is that, my lord, after that, my lord, rejection order, that is the progress of the investigation, and during the course of investigation, those are the 2 notes, my lord, the final still which are available. But my lord, earlier in those cases, my lord, their names are very much there, my lord. So 183 statements are also there, my lord. 180 is also there. Some, my lord, witnesses, my lord, implicated some are not implicated all. Because, my lord, there are 2 numbers of affairs, my lord. But, my lord, in the case, my lord, that was also lost. And from, my lord, going through the, my lord, that is the case there, and going through the statements, then, my lord, there is a dispute between both the groups, and it comes to that position.
So you would hardness and regarding possible. And also hardness to be able to regarding it. It's an application, the section students, information expenses, update the case diary receipt. Next, it is submitted by Mr. Kram. That they present this petition. They have no comment. However, the penalty of this case, the petition number, your arrested was petition number 2, na? Petition number 2, Saidur is arrested,
No, madam. 8, madam. Mizanur Rahman got arrested.
which is a middle. Petition number 8, that is Mizanur Rahman. Already got. If further submitted that the case is not registered in section 3, subsection 5 of the BNSS. So prove any common intention will be on the accused in the premises. However, it is a fact that these petitioners were also present in the group at the time of the incident, but they have not committed any such offense. However, not the accused petitioners are ready and willing to extend their cooperation for the investigation of this case if they are granted with the privilege of Mr. Bosha, the learned PP submitted in his report that prior to the date of election order, the city revealed a sufficient incremental matrix against all the accused persons who were alleged to be involved in the sale of. But he submitted that as per recent note of the IO after the preparation of the progress note. Progress note, it is seen that the case has already the case is ready for filing the charge sheet. And considering the report submitted by the IO, note of the IO. Sorry, while and further submitted that the mail may be considered on the basis of the notes submitted by the IO in the case diary. We further submits that from the note of the IO, it also reveals that case the investigation is almost completed and case is ready filing the charge sheet. Next one. Hearing the submission made by learning counsel for both sides. I have verified this record and the earlier election. It is the fact that there are sufficient incrementing materials against all the experts and the nature and gravity of the nature of the offense is also grievous. But considering the note of the IO, after completion of after completion of the investigation and other aspects of the case, I find that the present used petitioners bail for the and the pre-arrest bail for the present accused petitioners may be considered in view of this. আৰু এইটোৰো একেই দিব এজনৰ কাৰণে আছে same sentence. খালি ইয়াতে এটা submission দিব পাৰে তেখেতক submitted by Mr. Hussain that the accused petitioner is a 65 years old person and he is entitled in the present case only because he is the father of the some of the persons. That he has no involvement in the commission. Okay, we are granted bail. We considering the note of the IO, actually we granted bail. Extend your cooperation because transit is not yet late, till late. However, on the basis of the note of the IO, we have considered your bail.
Okay. And only one minor that may be recorded minor. This minor in both the petitions minor, all the accuser, they are all are apparent.
It is submission on the key both sides. That all the accused petitioners name, all the accused petitioners
Yes,
are
ma'am.
the
The
apparent.
implication to the materials are there, that has already been.
The progress of the investigation, IO might
That
have
I am
arrived.
also not getting because my lord, otherwise my lord, their implications in other matters are there.
Hmm.
That note my lord came out. My lord,
Don't know regarding after the investigation.
Radhat can be also my lord appearing on behalf of the.
Oh, sorry,
Yes,
sorry,
ma'am.
sorry, very sorry. তেখেতৰ নামটো for the informant as per number. Okay, Mr. B. Yes. Yes, Mr. Dhor, what I have said earlier also, we're considering your submission and the metricity case diary and the injury sustained by the victim. We rejected your this bill there. But now we have seen as the
Yes, my lord.
pointed out by
Otherwise
Mr.
has
Pusho.
Previous injury my lord, that.
Otherwise,
that
previous
report is
injury
there.
was there, everything was there. But during the investigation,
Yes,
we are not in a position, even Bosho is also not in a position to say anything in regards to the note submitted by the I. So only considering the note of the I also we consider. Let us see. They may extend their cooperation. In the meantime, if anything comes out, then we may otherwise also.
You're also including very
Yeah, the data in the local.
May I please your lordship?
Yes.
Lordship, this is second time pre-arrest bail application, my lordship.
Huh.
Rejection order is page number 14, my lordship.
Page number. You have received here the case.
14, my lord.
My lord, in this matter, earlier, my lord, that was rejected on 2025.
Yes, yes, very recent.
Yes,
Yeah.
my lord. My lord, we received the city, my lord, recently, my lord, which is sent on, my lord, to us, my lord, to our office, my lord, that is on 13/10/2025, my lord. My lord, my lord, yesterday.
Oh, what?
Well, but my lord, the thing is that, my lord, in the, my lord, CD, my lord, after, my lord, that is,
The last entry in the CD.
37/25, earlier rejected on 20/2025.
Yes, yes. Last
Yes.
entry is on.
Last entry, my lord, is difficult for me to also say, my lord, because, my lord, this is the last page, my lord. Before that, I can understand, my lord. But, my lord, date is not mentioned, my lord.
2003 to 14. Lord, yes.
Take-
3 more.
Date is not mentioned, my lord, not come to my notice, my lord. Before that, my lord, this is on 7.
There are some dates that is on 30/07/2020.
Yes, my lord. But, my lord, next page, my lord, that was not, my lord. There. There is sent, my lord, recently on 13/10.
No, these are English and Assamese or what?
My lord, Assam is my.
No, no. Assamese, I can see.
Before that, my lord, there was type, my lord, but this, my lord, this page is, my lord, handwritten, my lord.
Yeah, Karnataka. Yes.
Only, my lord, that is, my lord, in the morning, my lord, they open the CD, my lord. That can be understood, but that is not, my lord, available,
Then now what to say?
my lord. Then, my lord,
Because last
my lord, this
entry
time,
as per
yesterday, my lord, 13/10.
yesterday, as per the previous note is of 30/07/2028, and our rejection order was on
Our
August.
rejection order 28/2025.
Yes, August.
August.
That is not up to date then.
Yes,
It cannot be considered as a.
no, it cannot be considered. Even that date is also not there.
Huh.
May I please your lordship?
Hmm.
With due respect, my lord, the petitioner is a student, my lordship, is a BA third year student, my lord. His examination is coming, my lord.
When he is
within this
commencing, examination is
examination, my lordship. This
will
is
be comments from which date to date.
my lord, maybe next week, my lord. That as telephonally informed, my lord. And my lord, with due respect, my lordship, he what admittedly he did, my lordship, he published the same on the
Now see, the question is a bit different. Whatever may be the reason, we rejected your bail application.
My lord,
So
my lord.
unless there is any ground, new ground, or on the same ground, we cannot entertain.
Not on
the bail
same ground, my
application.
lord. This is one ground is that his medical petition also like he was injured, my lord, falling down in the bathroom, my lord. That was also there, and his examination that is orally I'm submitting.
Medical exam, medical report you have brought from the hospital authority.
Yes. That is in page number 18, Your Honor.
When he sustained injury. Now what is his condition? We don't know anything. Page number 18.
Page number 18, Your Honor. And moreover, Your Honor, this is a case involved, my lord, the publishing of in the Facebook, Your Honor, this lottery ticket, my lordship. And
Pantop tablets were provided him, and one.
he fell down in the
the
bathroom,
crop
Your Honor.
was there. That part there is nothing. Here.
Yes. Moreover, my lordship, like on
When he fell down in his own
there is an
bathroom or his bathroom, the jail authority, jail. Inside
27
the jail.
eh?
When he got, when he fell down.
The medical report on dated 27/8/25, Your Honor. After rejection, Your Honor.
That is inside the jail. That.
No, my lord, the pre-arrest.
Pre-arrest, Your Honor.
Sorry, it is a pre-arrest.
Pre-arrest, Your Honor.
Oh, no medical emergencies.
Your Honor.
No medical emergency is seen. And
Yes.
you are outside the jail, you can very well appear before the examination.
Well, exam is there, Your Honor. Kindly student, my lordship, and this is not an heinous crime, my lord. But admittedly, my lord, what he has done, Your Honor, publishing in the Facebook, Your Honor. He has done because he is also a student. He sometimes Dream 11 he play. He also purchased ticket. I also acknowledge in page number 17, Your Honor.
Okay, we cannot take your consideration because there's no such
I'm not
new
about
ground.
Your Honor,
You're repeating the same ground. In the
Your
other
Honor,
occasion also you are saying. that
Your
you-
Honor, this sections involved, there are specific section in the DNS, my lord, that is 297, you're bailable, Your Honor. Even in the Lotteries Act, Your
Then
Honor.
it's okay, bailable, then it's what is your problem? If it is
And
bailable,
but that section written is cheating, Your Honor, and petty offense, Your Honor.
no, we are saying bailable,
There is, as per this Lotteries Act,
is it bailable?
is a
Then
bail.
it's good for you only. Why
Yes,
you-
but the section involved, put in the FIR, is non-bailable here.
that is
So
not
please,
bailable and
considering
he
only
is
because of the
cheating.
student,
He was cheating. That is the case.
Your Honor,
And when we peruse the case diary, I mean, he is the main culprit we have seen.
only
He is
public.
the one, he is the main culprit and he is the mastermind of entire.
Yes,
That's
yes,
why
Your Honor. That
he
was written in the CD, Your Honor.
the record,
Page number 16, Your Honor.
support of, it is submitted by Mr. Busho that no CD is received. It is not an up-to-date one and hence he submitted that up-to-date case diary is required and there is no entry after the rejection order on 2008. The case diary be returned according
He
to
joined the
directing
investigation also.
directing the IO to furnish the updated case diary on or before the next date of this. Your I mean your exam is commencing on the next week. You don't know the date.
No, I don't know any date. I'll confirm. Your Honor,
Then we are listing it on when can we list
before
it?
example, please keep a report.
22nd.
22nd will
There is
reach
only case.
at 22nd because they have to take it back and then in between 18, 19, 20, 21, all are holidays. So
Holidays,
22, it may not reach on 20.
Yes. 27, my lord.
Maybe on 20.
Look, he may be again may be protected, my lord, because my lord was once pleased to protected. He joined the investigation after your protection, Your Honor. He got the interim protection from Your Honor. That is
Interim
also reflected in the
protection
order. He has joined the investigation, Your Honor.
Interim protection, he was on
Earlier he was protected, Your Honor. Kindly see para 7, Your Honor.
interim protection.
Para 7 of the page number 16, Your Honor. Page number 16, para 7, Your Honor.
Page number 16.
Page number 16, para 7. He joined the investigation, Your Honor. Nothing to recover him. Kindly consider because student, Your Honor.
No, we have
I never
rejected
before,
your-
I never beg like
rejected
this
your
before, Your Honor.
pre-arrest bail where we have granted your hearing.
No, my lord, it is admitted fact that after obtaining the pre-arrest bail, the accused petitioner appeared before the IO and his statement also recorded, Your Honor. His statement was recorded, Your Honor.
That's what I'm saying. After perusal of the case that your interim was also vacated, considering the seriousness of the case. Earlier you were on interim.
In the
That
interim,
was also rejected.
my lord,
So how can you expect that interim will be continued? I don't know. I couldn't follow.
I'm not that continue. Not I'm asking for a fresh because of his exam. He may be protected, Your Honor, only for
Sorry.
1 week. Maybe in the
Your
next.
interim was rejected by us. Your interim was vacated. We cannot. It's not a case. Near 27.
27.
20. Considering your nature of the offense and your involvement and he was the main culprit, considering all these aspects, your interim prayer was earlier rejected. I mean, you are granted with interim. You have admittedly you appeared before the IO and statement you recorded. Your statements were also recorded by the IO. That is admitted fact. We are not denying it. But considering the entire aspects of the case, it find that it is not at all a fit case for pre-arrest bail, and that's why the interim earlier order of interim pre-arrest bail also vacated.
But he's a student. His career will be ruined, my Your Honor.
Question of law.
His career will be ruined here.